Okay. Last time we talked about ultra-hazardous liability, which is a type of strict liability, and we were talking as we ended about the Union Carbide case. That was the last thing I think we talked about. And of course, it was actually two cases, one in India and one in West Virginia. The one in India was far worse, so we'll give them a little credit for maybe not doing quite so badly here as they had done there. But a lot of the credit goes to the fact that here in West Virginia it was not located close to the city. It was further out, and so that decreased the fatalities right there. But other than that, it was the same leaky valve. They had watered down the MIC, the toxic substance. Anyway, it all goes back to Rylands. The water escaped and destroyed somebody else's property. In this case, however, we're talking about people dying. So ultra-hazardous activity, we went from unnatural, so the water leaking out of a dam was seen to be unnatural because it was put there by man, the water was put there and there was unnatural, to abnormally dangerous, and now we talk about ultra-hazardous, meaning that people generally need to be involved and be harmed. And the people in Virginia, West Virginia, were harmed. Not quite as seriously. They went to the hospital, they got sick. They were scared because they had heard what happened over in India, and so naturally it was probably quite an upsetting event. And so it didn't involve as many people, and these results were not quite as severe. The company becomes liable in these kinds of instances where these things happen. And also it gives them bad PR, and so it's something that they would rather avoid. So it's not the end of the story in England anyway. With the English, there was a case, the Transco Company versus Stockport Metropolitan Borough. There was a leaky pipe. Liability was relegated to nuisance law in that case, requiring foreseeability. For this case, the thing did not have to be an inherently dangerous item. So under ultra-hazardous liability, it has to be an ultra-hazardous liability. So certainly in water is not an ultra-hazardous activity, right? It's not abnormally dangerous normally, but they said it was highly dangerous. The risk was instead in its behavior if it escapes. So a leaky pipe went through and caused damage to property in a store, just like the water was causing damage to property. Anyway, so that was a development in English law. Is that something that we'll be seeing here? Maybe. Maybe they'll start treating it more like negligence. And okay, now we're going to talk about animals and strict liability. Animals with known dangerous propensities, you have strict liability for those kind of animals. You have strict liability for wild animals. And this, by the way, includes monkey. We once had a textbook that said monkeys were not wild animals. They are wild animals. They are not domesticated animals. What is a domesticated animal? A domesticated animal is one that has been living with humans long enough to know that you don't bite the human. You know, the monkeys haven't learned that. You have a chimp and you raise a chimp in your apartment, he goes up to be a great big hairy thing, and he'll trash your apartment if he's upset with you. And so you know, he can be very dangerous. So wild animals, and that includes even small animals. So if you keep snakes or insects that are poisonous, they have wild propensity. It includes animals like skunks. Skunks have a dangerous propensity to squirt some toxic, not maybe dangerously toxic, but certainly awful smelly liquid on you. And so porcupines, I mean, all these are considered to be inherently dangerous. Pets who have previously attacked a person would be included as animals with known dangerous propensity. Pets declared illegal. So if your city has declared the breed of dog that you own illegal, could be a pit bull, could be could be anything, German Shepherd, whatever they declare, Rottweiler, Doberman, you know, cities will come up with these lists of names. They're not always the same dogs, but they're oftentimes pretty much the same ones. Corsos, so pets are declared illegal. You're going to be strictly liable if they do harm to anybody. So you're just taking on that liability. You can't get insurance if they're illegal. So if you look at these insurance policies, they will exclude dogs that are illegal. They'll exclude dogs that have known dangerous propensities. Insurance things. Anyway, dogs trained to attack. Dogs that have attacked. Either he's trained to attack, and which would include police dogs. What do the police do with dogs if they can no longer use them? If they decide the dog isn't really, up to snuff, they destroy that dog. They trained it to attack, and even though the dogs are supposedly trained to just simply grab people's clothing, they don't want to be liable for that dog should he attack a human being at some later date. Pets who previously, has your dog attacked somebody? That means he's a dog with a known dangerous propensity. Powerful animals such as bulls and cows and elephants, who because of their great weight and power can destroy things and can cause accidents. So your cow escapes, you're a farmer, you have to go out and collect him, otherwise you can be held liable for that damaged car. And if somebody was injured, you can be held liable. Things like deers. Do you have a deer farm? Is your deer out there on the road? Deers have been known to slide through the window of cars and kill people. And so, if you have these kind of animals, if they escape, you become liable. So that was the line from Rhode Island. If you keep something that's abnormally dangerous, unnatural, if you keep something ultra hazardous nowadays, we consider it to be something that if it escapes, you are responsible for whatever harm it does. Some states hold owners actually criminally liable. Matter of fact, I think most states hold people criminally liable. The statutes vary. A lot of the statutes will only be misdemeanors, or they might be lower level felonies. Maybe the most you could get would be a 5-year sentence. That would be the maximum under maybe some of these sentences. But nonetheless, those misdemeanors and those short felonies, they basically can be turned around by federal laws that indicate that you actually become liable. So you're actually maybe going to go to jail. You can be prosecuted. And so I don't know. They prosecuted that lady up and her husband up in Michigan, and it was they brought second-degree murder charges against her because it was a heightened sentence. Why did they heighten the sentence? Well, because the dog had already previously bitten, and they knew it. They'd been told. In a sense, they were warned, and they continued to keep the dog, but they weren't able to keep it in a pen, apparently, and it was constantly escaping and attacking people. So, okay, dog owner, this is the case that I was talking about. The dog owner was charged with second-degree murder. Not only are you going to be liable, perhaps you might be, facing murder charges. A Michigan couple's cane corsos, this the type of dog comes from Italy, had attacked 2 victims fatally, and fatally attacked Craig Sisma, 46. It chewed up the other victims very badly, by the way, also. On July 23rd, 2014, as he jogged down a rural road. The defendants pled no contest to a lesser charge of harboring a dangerous animal, so it's probably a misdemeanor or a low-level felony, causing death, a 15-year felony. So the dogs had escaped from their pen numerous times. Judge Bernard clearly believed that the 2 had knowledge their dogs were dangerous animals. They're on record for having that. And so they wound up pleading guilty and got 15 years. That's in addition probably to paying damages. Still going to be liable for damages. Constructive manslaughter. In the United States, constructive manslaughter, also known as unlawful act manslaughter. Manslaughter is not murder. But second-degree murder might be a manslaughter charge. A manslaughter is not the same as a killing, but it's an attack on a person. It's actually a killing that's not usually considered to be murder. It covers a person who causes the death of another while committing a misdemeanor. Such a law may allow for conviction for homicide if the misdemeanor law that was violated by the defendant is a law designed to protect human life. So that's what these dog statute laws are about, right? And so this can be converted into manslaughter, and again, you can get 15, 20, 25 years under a manslaughter charge. I actually had a man who was convicted of a manslaughter. He was defending himself, he said, but he killed the guy, and the guy just happened to turn around before he shot him, which made it no longer self-defense. Even though he had been previously beaten up by the man, and therefore could claim provocation as an extenuating circumstances, he was nonetheless convicted of manslaughter and was serving 20 years in prison on a manslaughter charge. Well, the same way with these dog statutes, it could be turned into manslaughter or second-degree murder or some other serious felony that could result in quite a bit of time in the Hooskow. Okay. Such a law may allow for conviction for the homicide if the misdemeanor law that was violated by the defendant is a law designed to protect life. And I would add that actually it usually has to be a case where the defendants knew or should have known that this could have happened. So it has to be foreseeable. It's not strict liability in a sense. It's not absolute liability. It's strict liability. Okay, so absolute liability, it's different. Anyway, owner's liability for dog attacks. And so I have here the statute in Indiana, and this is all kinds of things. If a dog without provocation bites an animal who's acting peaceably and who is in a location where the person may be required to be in order to discharge a duty, could be a mailman, right, imposed upon that person by the laws of Indiana, the laws of the United States, or the postal regulations of the United States, the owner of the dog is liable for all damages suffered by the person bitten. The owner of the dog described in Section A is liable for damages even if the dog has not previously behaved in a vicious manner. So we used to say a dog has one bite. That was the common law rule. Nowadays, if you know your dog is dangerous, you're going to be held liable for it. So you need to be responsible. Here, this statute, if it's applied the way it's written, I think it doesn't even give him any sort of consideration, except that he bit the mailman. So I guess you could show in mitigation the fact that the mailman somehow provoked him, but I don't think you want to rely upon that too much. So if you have a dog that you know might be dangerous, you probably want to not just keep him away from the mailman, because what if he escapes? So you lock him up, put a big chain around him, and he still gets out somehow. And so this is what some of these dogs do. Dogs can jump like over fences 7 feet high, 8 feet high. They can jump over those fences. The owner has no knowledge of prior, even though the owner has no knowledge of prior vicious behavior by the dog. So what is vicious behavior? So, if he attacks somebody, is that vicious behavior? That's a matter of interpretation, I suppose. And also, it goes on to talk about these as being misdemeanors. What we've been talking about are misdemeanors. The owner recklessly, knowingly, or intentionally fails to take reasonable steps to restrain the dog, where he knows the dog is actually dangerous. He needs to do that. The dog enters property other than the property of the dog's owner, and as a result of the owner's failure to restrain the dog bites or attacks another person without provocation. So you can't just leave your dog roaming around there if he has a tendency to bite people, especially so. The offense, so that's a Class B misdemeanor, and there's a Class A misdemeanor. If the there's also dog bite liability, which is a criminal offense, except as provided in subsection B, the owner of a dog commits a Class C misdemeanor, okay? So there's another one. The owner recklessly, so there's various kinds of things. The owner recklessly or knowingly. What's reckless? Reckless is beyond negligence. So you might call it gross negligence. It's big negligence, where you should have known a lot better. And okay, and then it gets down to some things that are not misdemeanors, but are minor felonies. The person has been convicted of more than one previous unrelated violation of this act, or the violation results in serious bodily injury to a person. So you're responsible if it's really very bad, if the injury is very bad, even though he had not previously attacked him. And so, and that's a misdemeanor, Class B misdemeanor, which I think could get you 5 years in prison in Indiana. And there's also a second felony, which is a 1 to 2 year thing, which is along similar lines. So that's some of what I wanted to say. Now here's civil liability. So we talked about this, the criminal aspect of it. If that isn't enough to convince you that you don't want to have a dog that has these characteristics that's likely to attack, if you do have one, you best get rid of it, or, and I know this is kind of cruel to say, you might be very fond of your dog, but he's not worth it, and that would be my advice to you if you have such a dog. So this section provides for, there is some exceptions made for dogs that are hunting, that you know, or maybe in custody, but you know, they've got to be, you know, not if the injury is really very serious. Yeah, I had a client, and she had her son, who was, I think at the time, just in grade school or maybe in kindergarten, and he was bit by a neighbor's dog quite severely. Had to go to the hospital and get stitches, and you know, so I interviewed her, and I had a friend of mine come in who had handled these kind of cases before, to advise me on how much we could sue, or what should I tell her we should sue for. And he decided it was worth $20,000. Why $20,000? You might say, just stitches don't cost that much. No, it's not the stitches that cost that much. It's the psychological counseling. And, like I said, she didn't bring her husband with her. I knew her from childhood. She was a childhood friend, and I've known her all my life. And she was ready to go with it, but she said she needed to talk to her husband, and he had to agree to it. So she did, and he decided he didn't want to bring the case. And that boy, as far as I know to this day, I know that when his grandmother died 20 years later, I saw the boy, and he actually had a phobia for dogs. So this is a terrible, embarrassing thing to have, to be embarrassed of even ordinary little dogs. So I mean, we're talking about people who are maybe afraid of little puppies, dogs that are non-threatening, and you know, they're afraid of them. Because it's a psychological thing, and they can be helped with psychological counseling and treatment. But that's what the $20,000 is for. That's why it's so large. So it's a lot of money. It's not just some stitches. Okay, so those are there too. And also, there are often tetanus shots, then there's pain and suffering. And can be based on a combination of all three. Oh, I'm sorry, I'm getting ahead of myself. So what I'm talking about here is dog liability, right? You know, and so that's in the nature of dog liability. Like I said, if you do get bit by a dog, you usually have to have rabies shots, and those I understand are very painful. And you know, so you're talking about a trip to the hospital. If nothing else, maybe it doesn't even matter whether or not your skin was broken. I think if the dog if you came in contact with a rabid dog, you become liable for all that. So it can be, anyway, can be quite severe. So you're talking about liability, you're talking about possible time in prison. And so it's not something you want to get into. So I hate to tell people that, but I mean, that's the truth. It's what I would do if I had a dog like that. I love dogs. And product liability. Well, product liability is actually has three bases upon which it is based. It can be based on strict liability, negligence, or warranty. It can be based on a combination of all three, which is very common to do, because there are advantages to adding more than one charge, and we'll see what those are. Strict liability is more likely to win So you're going to win possibly with the strict liability, but there are other things that happen if you're going to allege negligence. If you're going to allege negligence, maybe it's gross negligence, in which case you could maybe get punitive damages, so you can increase your damages. If you can allege warranty, there's more likely that the jury will find that they do have a defect. So you're showing a warranty violation, that the product was defective. So I'm talking about then suing the manufacturer. So you can join the manufacturer as well as the driver of the car. Who knows whether it was the driver's fault or the manufacturer, or the fact that the car didn't work right. And I've seen some cars that just came out of the factories. I had a friend of mine had a car, and a couple of weeks after buying a new car, brand new car from the factory, her engine fell out on the road. Now that's a major thing to fall out on the road and could cause damage to other cars. And shouldn't happen, right? But things like that happen. It may be 1 in a million, but it does happen, and so this has got to be a cost of the manufacturer. So one argument is that this should be a cost of the manufacturing process because the manufacturer has deep process. Whereas if we leave this loss liability to people, they're going to be going bankrupt. People who have injuries are not going to maybe be able to get recoveries or won't get full recoveries. Okay, so strict liability for products. What are the elements? The first element is the defendant must have sold the product. Now, he might be a manufacturer, in which case he made the product and then he sold it. And he may have sold it to a middleman who resold it. And so both of them are liable. Anybody who's in the chain of distribution, any seller. I mean, the manufacturer sold it to a retailer, or he sold it to a wholesaler, and a wholesaler sold it to a retailer. All three of them could be held liable for its product that was defective. If it was defective when they sold it, so it had to be defective when they sold the product. So if something changed in the meantime, say it gets to the retailer and the retailer says, I think it'll sell better if I put some fancy looking tires on there. I'll put better tires on there and I'll sell it better. So you replace the tires. Then, if that's what goes wrong with it, if the tire blows up, the manufacturer of the car isn't responsible for that. He put a different tire on there. And so, other things come up, like sometimes if you open up things, you may destroy the warranty, and that may also make it difficult to win in a strict liability case. So that's certainly true with computers. If you are a person who likes to tinker with his computer, add parts and take parts out, when you do that, you are oftentimes negating the warranty. And then it's just a question is whether or not you have changed it in such a way that you were the cause of the defect. And so I'm not concerned so much with your getting money back from the manufacturer. I'm concerned with what damage may happen if your product is defective. In some cases it's very bad, especially with motorcycles and cars and boats. But other kinds of things like ovens that set your house on fire, or refrigerators that leak, you might want some compensation for that. Market share liability. Now let me talk about defendant. Like I said, you have to have the defendant selling the product. So that's the first element. There was a case in California where women who had taken a certain drug, it wasn't thalidomide, DMS, DS, something. Anyway, that product caused birth defects, and it was not known at the time, even though they tested it very extensively and waited a couple of years to put it out on the market. It was a morning sickness drug, and women who took it for their morning sickness were giving birth to children, and it took a while before they found out what this defect was. As young women who were born to these women, who were, the fetus when the woman took the drug, that fetus, if it was a female, when it got to be marriageable age, just say, they couldn't have babies because they didn't have ovaries, and that was figured out. Scientists figured out that was because of this drug that their mothers had been taking, this morning sickness drug. And so the trouble was that they didn't find out about this till 15, 20 years later. And most of the women and most of the children didn't know whose drug they took, so they have to name a defendant. And therefore, one clever lawyer decided that he would sue all of the possible defendants and make them pay in a class action suit to all of the plaintiffs who were injured, and the liability would be based on market share liability. So I don't know, they've changed a lot of that, those laws now. I don't know if you can do that again or not. Maybe not. Product was unreasonably dangerous, so it has to be unreasonably, that is, has to lead to some sort of problem that you wouldn't want. So unreasonably dangerous when sold. The product injured the plaintiff. Okay, and the plaintiff could be, in some cases, somebody who didn't buy the product. So, you know, if you're driving a car and it's got defective brakes and you have an accident, you might get injured, but then again, it may be that a passenger in your car got injured, or some person walking on the outside, or somebody in another car or on a bus. Somebody else on the outside of your car may be injured. And so whoever gets injured, whether in the back seat or sitting beside you, can sue and claim strict liability. And you should have insurance, by the way. The injury was foreseeable to defendant seller. You know, so the defendant seller should have known this. So, you know, one of the more famous cases is the Pinto Ford, the Ford Pinto. There was a car that was manufactured in such a way that it had a gas tank that would explode upon being rear-ended, basically. And do cars ever get rear-ended? Oh yeah, they get rear-ended a lot. And you know, it's not necessarily the driver's fault who's driving the car, but what was happening with these Ford Pintos, in a lot of cases where there was a rear-end collision, the trunk would be pushed in and into the gas tank, which was back in the rear of the car. A rod, which was badly placed, would be driven into the gas tank. Metal on metal causes sparks, and these cars would catch fire, and they'd blow up into the passenger compartment. So they were right behind the passenger compartment, and a lot of them were doing that. And so that was maybe one of the worst things. What made it really bad was that they had discovered the defect before they sold any car. But rather than call those car backs and fix them and delay production, they went on producing them and selling them. And when it came to being sued, they tried to claim that you know, they shouldn't have to build the car like a Sherman tank. Well, the rule is with cars is you don't have to build them like a Sherman tank, certainly. That's a bit of a straw man. You know, you do, however, need to have a dog that's, I'm sorry, you need to have a car that is reasonably safe, not unreasonably dangerous. So these cars were unreasonably dangerous to the people riding in the passenger car. So it was terrible, terrible burning injuries to these people. An awful kind of thing to have happen to you. Anyway, so that's strict liability for products. And so all kinds of manufacturers, not just cars and automobiles, but all kinds. We had a lamp, which was a stand-up lamp, and it had a halogen bulb in it. Halogen bulbs are very, very hot. And what had been happening was these lamps were manufactured, and people would buy these lamps and sometimes set them close to maybe a patio door. And somehow the curtains on the patio door, sliding glass door maybe, were thrown up into the lamp, and there was nothing stopping it from coming into contact with those very hot bulbs. And these shades were catching fires and setting the house on fire, causing damage. And you know, they were liable for that. So was that foreseeable damage? Yes, that was foreseeable damage. The jury decided so. Foreseeable damage is a question that's usually oftentimes left up to the jury. Some judges will decide it, and you know, in some way it depends also on the statutes in the state as to how it proceeds at court. Anyway, that was a very dangerous kind of thing. So, you know, the manufacturers had issued recalls for these lamps. However, when we tried to, you know, to get, actually what wasn't so much a recall was that you could send in and they would send you a grill that you could place on the lamp. We never did get a grill to place on the lamp, so for a long, long time that just kind of sat in the basement, not being used, not connected. Anyway, product injured the plaintiff. The injury was foreseeable to defendant. Yes, foreseeability. Foreseeability is always required. You have to show causation. You have to see so that it's foreseeable. That's proximate cause, isn't it? Unreasonably dangerous product. Must be dangerously defective when sold. Defectively, there's 3 ways that a product can be manufactured. You could list a longer list, but I'm going to collapse some things all into one, which I call communication defects. Defective manufacture. That is, well, you know, the person on the assembly line who was supposed to put in the brakes didn't notice that the brakes he was putting in were rusty. He should have noticed that. And it wasn't caught by the quality control guy either. And it gets out of the plant like that. And then when they're out on the road, it fails. And, you know, experts will look at the accident and they just determine that, oh, what the problem was, this brake failed. And then that's an unreasonably dangerous product. Did they know it had bad brakes in it? No. If they'd known, they would have taken it out. So it's not like they intended to put this car out on the market or intended anybody to be harmed. This is what negligence would be, except that we make it, in the case of products like this, a matter of strict liability. So defectively manufactured, that is flawed in a very serious way, in a way that makes it unreasonably dangerous. That's, you know, it has to be unreasonably dangerous. Design defect, that would be the Pinto case. They had designed it badly, putting that rod and putting that gas tank where it was. They redesigned it and were able to produce cars that were not dangerous that way, that didn't blow up when we were in them. And but if you bought one of those early ones, it was even this, I don't know, they may still be out there today. Although this was back in the 80s. And some people would buy them. I had a brother-in-law, he bought them. And I said, don't you worry about the family? But he bought one. They were cheap. You know, after it was found out what they were, people were not willing to pay what they were originally paying for them. So I feel sorry for the people who originally paid too much for them. That's too bad. You can't sell it, resell it. It's a risk you take when you buy something, isn't it? It may not be worth as much as what you paid for it. Prices can change for all kinds of reasons. Black sheep, right? No, black swan. Anyway, now this I've got so dangerous defective product. That's one thing in design defect. I'm also going to talk about what I call communication defects. And the first one would be that some products need to have a warning. There's some products that you cannot make safe completely. You can make them as safe as possible, but they're still dangerous. Things like nitroglycerin, blasting caps, automobiles are an example. You cannot make them perfectly safe, but you don't need them to be dangerous. So in some cases you might need to put a warning on them if there's something peculiar about this product. But that will not necessarily do you any good if you can foresee somebody might be injured by it. So if you know it's going to harm somebody, the better thing is to change it, if you can. Instructions. So the instructions could be badly written. So bicycles, I think they're dangerous. You know, a kid on a bicycle can get involved in an accident just like a car could. They're traveling maybe fairly fast down a road, and they can go through an intersection and a car doesn't see them. All kinds of things can happen. Anyway, so and if the bicycle is defective, even more so. It could have bad brakes too, right? And the brakes can fail. Tires could go bad. You know, anything like that. So let's say that the parents buy a bicycle for their child, and you know, dad stays up at night, or mom stays up, one of them stays up at night, and attempts to put together. Let's make dad. I think he's more likely to do it, but also he's more likely to get into trouble this way. I think. Of course, I won't eliminate women entirely from possibly doing this. He's to put together the bike. He's got instructions. He thinks he knows how to do it, so he's going to go put it in. But he's drunk. and he puts it together wrong. And he thinks he's got it together, but actually, when you know, Junior or the little girl gets on it, whoever whoever's bike it is, tries to ride it, it falls apart and she crashes, and she's injured. Is that bad instructions? Well, this is why manufacturers of things like that, who have products like that that have to be put together, will spend a lot of money in writing the instructions to make sure, and then they'll test it, and they'll have some father who's drunk, they'll have some man who's drunk try to put one together and see. And what they're looking for is not whether he can get it together or not. They're looking to see if, when he does get it together, it's not put together right and it's dangerous. And there's one or two things they can do. They can look at the instructions and say, well, maybe it's not the instructions. If it's not the instructions, there's still something they can do. Oftentimes they can put a bump somewhere to make it impossible to put it together that way. So you may have come across this, I know I have in putting together things. Sometimes there'll be a bump on a rail, and you say, well, why they got that bump there? I can't put it together this way. And then you look at the direction, oh, you're not supposed to put it together that way. and you know you're an idiot. So, you know, and so that's it. So instructions and warnings are all things that have to be very carefully written, and so you need to pay some money to get a guy who knows how to communicate. And advertisements. Advertisements are also things that can cause people to do the wrong thing. And so basically, and I would include in this instances where a manufacturer has somebody demonstrating his product on you know, in a movie. If you show a this actually there were two cases like this. One involved a Jeep, and one involved a truck. And this Jeep and this truck were shown being driven off road, you know, through the woods, jumping over creeks and that kind of thing, you know, and it was being shown being driven, and in the car, in the Jeep, and in the truck, in the back of the truck, and you know, in the Jeep, there were all these kids. It looked like to me like the car was, these vehicles were overcrowded. Anyway, but I guess the idea is that you're encouraging people. Then you're encouraging people to do the wrong thing if you're showing them being used that way. And actually, the vehicles were not that stable. They would easily tip over if driven the way they were being shown in the movies. They were being driven by stunt drivers who had carefully planned out, you know, these these difficult turns and maneuvers that they were doing beforehand, so that they knew what they were doing and they knew exactly how to do it, as opposed to some kids who hop in a car and go down the road and, you know, just drive it like crazy. But that's the impression that these people get, and there are lots of kids who were doing this kind of joyriding in these vehicles and being injured. What was interesting about the Jeep was that it actually had a roll bar. You know, roll bar is if the car rolls over on its side, say you try to turn too soon, too quickly, and the car rolls, which will happen after a certain speed. I think it's 50 miles per hour. If you're going 50 miles per hour, you better not make too sharp a turn real quickly. You need to slow down. And that's why you see the expressways never really have these sharp curves that you might see in other places. They you know, will build over a valley to avoid that. You know, if the car rolls over and it's got a roll bar, then you know, that protects the passengers to some extent. But in this case, it did not provide any protection because it was made of cheap aluminum that wouldn't support the weight of the vehicle. So it was more deceptive than anything. So I think it actually made the vehicle even more dangerous than it was to put that roll bar on. Why did they put the roll bar on there? They obviously didn't do it for the safety of the passengers. They did it to sell the Jeep, which was not meant to be an off-the-road vehicle. Neither was the truck. And they knew that at the time. It was not designed for that. And they couldn't sell it as a street vehicle, so they sold it as an off-the-road vehicle and showed these people this very stupid commercial. So you don't want to be advertising your product in a way that causes people to do silly things. There was a radio station that was offering a reward for anybody who could catch up with a certain car after the radio announced that, okay, if you see this car, you get it. So the car had the name of the radio station on it, WXXX, whatever, and it was a bright orange color polka dot, so you weren't likely to mistake it for some other car. And it was being driven through the town, and the first person who would get to the driver and tell him, tell them the call letters of the station, and could claim this prize, $500. Well, people were going nuts. They'd see the car and they would drive crazy to get to the first one to talk to the person, and they would, and so some people got injured, and they then sued the radio station because its advertisement caused them to do that. So there you have it, advertising instructions. I guess I could talk manufacturing defect. Yeah, that's what I was going to talk about. The product sold was dangerously different from the design of the product intended to be sold. Okay, otherwise that would be design defect. It might be both, but anyway. Where the product has passed through sellers and sellers, the more remote sellers can assert that it was altered after they sold it by a subsequent seller. So the most remote seller would probably be the manufacturer, but not necessarily. The manufacturer maybe doesn't he makes cars, but he doesn't make tires. Instead, he buys tires and put them on there. What if it's the tire? Then the manufacturer of the tire is the remote seller, most remote. So like I said, if indeed a retailer decides to put different tires on there and what goes wrong is the tire, then that's going to relieve everybody who sold it when those tires weren't on that car, because it's the tire that was defective. So that would be a defense that a manufacturer maybe could assert. I didn't put those tires on there, or a middleman like a wholesaler could assert those tires weren't on there when I sold it. Somebody else did it. But it also applies to people who tinker with cars. if a person buys a car and then he tinkers with it, he changes the tires, then he's liable. Anything he changes or plays around with, he's perhaps eliminating the possibility of being able to assert that he can sue somebody for it because it's defective. I got a case that's right on point on that, and I'll talk about it in a minute. Where the product has passed through several sellers, more remote ones are oftentimes relieved of liability. Otherwise, they can all be held liable for the full amount. So it's joint and several liability, right? That it was altered after they sold it by a subsequent seller. Yeah. Okay. Okay. So let me tell you about this one case, and I happen to have known both of the lawyers on both sides of this case. And the case was one involving a General Motors car, and what it was is that Taylor had a very powerful Chevrolet with a very big engine, 546 or something, I don't know, 548. It was a powerful car and stronger than a lot of cars. And so when Taylor's car was acting up, he wanted to fix it. He's an amateur mechanic. It was a used car. He bought a used car, and something's wrong with it. So he took it to the junkyard, and he asked the junkyard he told him he needed a fan blade, a fan. And so they gave him a fan, and he looked at it, but no, they didn't give him a fan. They told him they didn't have any, they didn't stock those. So junkyards will sometimes stock some things, like they'll usually stock hubcaps and tires up in the front of the building. These are very commonly asked for parts. However, they'll sell other parts too, but they'll typically tell you, go out and see if you can find a car like yours out in the yard, and you can take that part from there and put it in your car. And so that's what Taylor did. He went out into the yard. He did not find a Chevrolet of his make and model. He instead found a Pontiac. He opened up the hood and looked at the fan blade, and then he compared that to the fan blade he'd already taken off, and they looked to be very similar except for one detail, which is there were extra holes in the fan blade that was coming off the Pontiac. Now, it may not have been a Pontiac. It also actually could have been another car too, but very few yellow cabs. Some cabs had been built which had that same fan blade in it. Anyway, so he thought, well, it's the same fan blade. I know these manufacturers, they use the same parts over on other cars. So sometimes you're buying a Cadillac and you might have the same part. One of the parts in there might be the same as the very cheapest Chevrolet, the Nova. Okay, the Nova might have a part that's also in a Cadillac, possibly. They're both GM products. And he says, well, this is a GM product, my car's a GM product. These look alike, I'm going to give it a try. So he puts the Pontiac fan blade in the Chevrolet. And unknown to him, the Pontiac has a much more weaker engine than his Chevrolet. His Chevrolet had a very powerful engine. He knew that, but I guess he didn't make any connection. Maybe he thought, well, it's a Pontiac, so it's probably pretty strong. And apparently it wasn't. And so as he was driving it down the road, test driving it, just outside the junkyard on the expressway that was there, he heard some rattling coming out from under the hood. So he pulled over. He pulled over to the side of the road to check it, and when he opened up the hood, the fan blade broke apart and lodged in his chest, killing him instantly. So he sued GM, and the manufacturer defense was he had misused the product. He said this product was meant to go in that car, he put it in another car, it was a misuse of the product. The lawyer for the plaintiff, the mother and the widow and her children, said, well, yes, we understand why they're defending that way, but we think that the manufacturer, GM, should have put a warning on the thing, and therefore it's foreseeable that this could happen. GM knows that these amateur mechanics go and substitute these parts. And you know, the judge, rather than declare a summary judgment for GM, allowed it to go to the jury. You know which way the jury went. They said, oh, this poor widow. And so GM has appealed, but the court said no, it was perfectly within the court's power and nothing unlawful about the jury deciding this case. We're not going to overrule the jury's decision on that. And so it was called foreseeable misuse. So if it's foreseeable that somebody may misuse your product in a certain way, you can't claim that as a defense. So that was that. And I think we already talked about a case of design defect, the Pinto case. So you understand what that is. Seller could have avoided or reduced the foreseeable risk of harm by adopting a reasonably alternative design, which Ford eventually did do, but already the cars were sold. The failure to adopt the alternative design makes the product unreasonably dangerous. That's what you need to prove if you're talking about that one. Thank you very much. We'll see you next time. And we're not quite done yet with strict liability, but we'll finish up pretty soon here. Okay.